California Penal Code 1299. In California state law, California established what's known as the Fugitive Recovery Persons Act in 2012. They turned the law around and then reenacted it in January of 2013. Okay, that is what paved the way for California PC 1299. All right, so California Penal Code 1299 was a result of the Fugitive Recovery Persons Act, which sets forth requirements and guidelines for bounty hunting in the state of California. Penal Code 1299.04 states that any person authorized to engage in bounty hunting, as per PC 1299.02, and we'll discuss the different criteria in 1299.02, but overall, you must be 18 years of age, no felony convictions unless you're a licensed bail agent, so bail agents can be felons, bounty hunters could not. Complete a minimum 20 hours bail education with a certified California Department of Insurance trainer, and complete a 40 hours powers to arrest PCA 32 course certified by California's Commission on Peace Officer Standards and Training, which is known as POST. So if you want the bounty hunt, those are the basic minimal requirements. You got to be 18 years of age, no felony unless you're a bail agent who's licensed in the state of California. Complete a minimum 20 hours bail education course with a certified instructor, and a 40-hour powers to arrest PCA 32 course certified by California Commission on Peace Officer Standards and Training. That's usually done through either a law enforcement academy, whether it's police or sheriffs, or a community college. Now, for those that are active law enforcement, if you have your post already, you have PCA 32. And we'll get to what PCA 32 is. There also is a firearms portion, which is not mandated for bounty hunters. It's a firearms familiarity course. It is advised. I would encourage anyone that's carrying firearms to get the firearms portion, but it's not required as per California Penal Code 1299. All that's required is the powers to arrest portion, which is basically a course on California Penal Code, and then you learn search and seizure, certain defense tactics, takedown techniques, and handcuffing techniques. California Penal Code 1299 continued. Again, there are no state licensing requirements for bounty hunters. In addition to training, when bounty hunting, bounty hunters must at all times possess and carry on their persons their training certificates, the PCA 32 powers to arrest and the bail education, the 20 hours classroom training, and defendant's bond paperwork. You gotta have the bond paperwork. So that's your contractual agreement, right? So if a fugitive is on the run and you're chasing after him, you're investigating their whereabouts and looking to remand your fugitive back into the custody of the courts, what gives you that reason is the bond paperwork. The bond paperwork is the contractual agreement between the fugitive and the bail company, where the fugitive promised to appear for a court date. They didn't appear for it. They didn't appear. They became a bail skipper. So that's what you got to carry on and about your persons. That is your arrest warrant, even though it's not an arrest warrant. That's the bounty hunter's or the bail agent or the private investigator's arrest warrant. You always want to verify that a warrant is active. Okay, so when somebody skips bail, a warrant is entered into the criminal justice computer database. You always want to call law enforcement and verify that, and they will give you that information. Anybody can verify if somebody else has an active warrant or not. So a person bounty hunting must also, in order to be California PC 1299 compliant, notify local law enforcement no more than 6 hours prior to attempting to make a fugitive arrest. In case of exigent circumstances, persons bounty hunting will immediately notify authorities of the local jurisdiction and, upon request, give written explanation within 3 working days, or notify law enforcement by phone, in which case the bail company is required to retain the name or ID number of persons receiving the notice. Interestingly, bounty hunters do have exigent circumstances that may apply in the process of fugitive recovery, which would exempt bounty hunters or bail agents or private investigators from having to contact law enforcement prior to recovering a fugitive. So long as you can articulate that in writing within a given and specified time frame, or if you can't, you contact law enforcement by phone and you just keep record of who you spoke with and gave the notification to, just for liability reasons, okay? But there are exigent circumstances. However, in most cases, I would encourage bounty hunters to contact law enforcement as outlined in California PC 1299, because you're still going to want to confirm and verify that they have a warrant. Courts make mistakes. Charges get dismissed. Nobody's perfect. So you don't want to be going out looking for a fugitive when their case was dismissed, because they're no longer a fugitive. And if you do and you find them and you arrest them, you just made a false arrest. So California PC 1299 continued. Bounty hunters must not identify themselves as law enforcement officers and may only use wordage on their credentials and or apparel which is consistent with bail industry nomenclature, like fugitive recovery agent, bail enforcement agent, surety bond agent, right? Refrain from using officer. Just don't use the word or the term officer, especially officer of the court. Don't do that. Something like this is sufficient. A t-shirt with yellow lettering. You can get them with white letters as well. There's companies that make fugitive recovery t-shirts, which is what this is. On the back it says fugitive recovery agent, and then you have a little star shield decal here with an eagle that says fugitive recovery agent. There are bounty hunters out there that use different logos and insignia. Insignia which they should not be using, that could potentially cause a reasonable person to believe that they're law enforcement because they're using wordage that says U.S. or United States. Don't do that. People have gone to jail over that. Don't wear a badge that says U.S. Fugitive Recovery Agent or U.S. Bail Enforcement. There is no such thing as U.S. Bail Enforcement. All right, it's not federalized. There's no federal statute. There's no federal agency. There's no guidelines that say you can do that. There are guidelines that say you can't use certain insignia and certain logos and marks which the government uses, or anything that can potentially cause a reasonable person to believe that you're a peace officer or law enforcement. You can go to jail. So don't do that. There are companies out there that call their company U.S. Bail Enforcement, LLC, or Incorporated. And that's how they get away with that, because it becomes a gray area since that's the name of their company that they've incorporated. However, the more you do things like that, the closer you are to going to jail, because it's just a matter of time before a U.S. Attorney's Office, a prosecutor, or somebody looks at that and says, hey, we don't want that in our community. So just be very cognizant as to how you portray yourself, because it's very easy to get carried away, especially if you just want to play the part and look the part and have a badge and have the gun and baton and all these things. Baton, which you can't have in California because it's a felony unless you're a licensed security guard with a baton permit. Nevertheless, it's easy to get carried away in the theatrics and trying to play that role, and forget that you're just a bounty hunter, which is great. You're more than a bounty hunter, but when I say you're just a bounty hunter, I mean you're not a peace officer, you're not a law enforcement. If you are a bounty hunter and you're full-time, that's your profession, that's great. That's a fantastic thing. However, still, you have to be within a reasonable means of identifying yourself. That way you don't misidentify yourself. California Penal Code 1301 states that any bail or other person who willfully fails to deliver a defendant to the court, magistrate, sheriff, or police as required by this section is guilty of a misdemeanor. So keep in mind, if you go and you capture your fugitive that you've been looking for, you can't just be driving around town like joking and hanging out and going to run errands and conducting your own personal affairs. You have to remand that fugitive back into the custody of the courts ASAP. as soon as possible. There's no actual guidelines that specify, but there is the reasonable person standard. You have within a reasonable time, you have to bring that person who's a defendant, who you just captured, who was a fugitive that you've now taken into custody. You got to get them back into the custody of the courts, all right, or hand them over to law enforcement. Sooner you do so, sooner bond is exonerated, the sooner you get paid as a bounty hunter. California PC 1299 continued. 1299.02 states that no person other than a certified law enforcement officer shall be authorized to apprehend, detain, or arrest a bail fugitive unless that person meets one of the following conditions. Okay, now we talked about PC 1299.04 that states you've got to be 18, can't be a felon unless you're a licensed bail agent, and so forth. But you have to meet one of these following conditions in order to be able to lawfully bounty hunt in the state of California. So you have to be a bail, as defined in subdivision B of section 1299.01, or a depositor of bail. You have to be a fugitive recovery person, as defined in subdivision D of section 1299.01, or you have to hold a bail license issued by a state other than California, or are authorized by another state to transact and post bail, in which case you have to be in compliance with the provisions of section 847.5 with respect to the arrest of a bail fugitive. So for anybody coming from out of state to do bounty hunting in California, there's additional requirements. All right, in addition to being compliant with PC 1299, you have to actually go through the courts for out-of-state warrants, and there's a process for that. Section 4, you must be licensed as a private investigator as provided in Chapter 11.3, commencing with Section 7512 of Division 3 of the Business and Professions Code. Or you have to hold a private investigator license issued by another state and be authorized by a bail or depositor of bail to apprehend a bail fugitive, and be in compliance with provisions of Section 847.5 of the California Penal Code with respect to the arrest of a bail fugitive. So again, if you're a bail agent from out of state or a private investigator from out of state and you want to come to California to capture a fugitive who you believe is in California, and you have information where they're at, their whereabouts, you've located them, or you have reasonable grounds to believe that you've positively identified their location, you still have to go through a court process if you're coming from out of state. For out of state folks, if you're a PI or a bail agent coming into California, you still have to meet the training requirements of PC 1299. And even if you didn't, I would suggest that you do. That way you have all your certificates and all your paperwork right and you don't get yourself in trouble. But if you are coming from out of state to remand a fugitive, PC Section 847.5 of the California Penal Code states that, in short, without having to read this entire paragraph, you have to go through a court. You have to file an affidavit with the court explaining the conditions and the circumstances, the nature of the offense that the fugitive is wanted for, what crime they committed, that they have a warrant from another state, what your reasonable grounds for believing where that fugitive is located are. You have to write everything down, and then a judge or magistrate can decide whether to issue a warrant for their arrest. Because remember that because somebody has a warrant in another state, that doesn't mean California wants to extradite. So